Hi, welcome to North State Law. This is Nick Dogle, owner and founder. Today's topic is demystifying legal jargon. What is a petition for judicial review? So this is specific to administrative law, and the professional license defense falls under that umbrella. So I'm going to use Office of Administrative Hearings as an example because you can end up either in front of your licensing board, and they'll have like hearing committees and things like that, or you can end up in front of the Office of Administrative Hearings. That's typical when you're dealing with the state agency. So say a state agency does an investigation, and in their determination, they have found that you have violated some of their rules and they are implementing some sort of penalty against you, okay? You file a petition or they file a petition, you end up in the Office for Administrative Hearings and you have a hearing. So say you have this hearing, evidence is presented by both sides, and at the end of the day, the final agency decision comes out that they're going to go forward with the penalty and find that you are at fault. Okay, you have 30 days from when that decision is finalized and that final agency decision is signed and entered into the record, and you can appeal that within 30 days. And when you do your appeal, you have to file a petition for judicial review with Superior Court in the county where you reside. You can also file it in the county where the agency or board is located as well. Depending on what county you're in, that you reside in, it might be more beneficial to file it there. It might be more beneficial to file it where the agency or licensing board is located. It just really depends, to be honest with you. But the petition for judicial review allows you to appeal the decision that you really don't want to a Superior Court judge, and they're going to do a review on the record. They're going to, there's a lot of different reasons for the appeal, and you have to clearly lay them out in the petition for judicial review. You can't really surprise the other side. That can be a little bit frustrating, to be perfectly honest with you, but that's what the statute says, so that's what you have to go by. There has been a relatively recent U.S. Supreme Court case that was decided in the summer of 2024 that overturned a very long-standing case called Chevron. It's overturned the Chevron doctrine. I'm going to talk a little bit about that more in another video further on down the road. But essentially, in my opinion, what that did is it created a little bit more of a level playing field for licensees and those that are required to have a license to conduct their business, essentially. I'll get into that, like I said, a lot more on a different video because I think that we need to get in the nuts and bolts about that, because I think there's a lot of things that are floating around about Chevron doctrine being overturned, and people will throw out lines of how it's so scary and dangerous and things like that, and I think that there's a lot of misinformation out there. Big surprise that there's misinformation on the internet. How about that? So we'll try to clarify that in one of the upcoming videos, but to answer the original question, like I said, petition for judicial review is just a filing mechanism to get your adversarial administrative decision up to actual Superior Court in North Carolina to have a Superior Court judge look at the case. So I hope that was a clear explanation on everything, and I apologize if it was not. So if you still have any questions, you can check out the blogs on my website, northstatelawfirm.com. You can also check out the other YouTube videos I have on the firm's YouTube channel. Also, if you can't find what you're looking for, like always, give us a call or text at 919-521-8810, and you can get a free 15-minute discovery call with a member of my staff. Thank you so much for taking time to watch my video. Hope you enjoyed it, and have a pleasant day. Bye-bye.